Good people of the jury, good morning. On behalf of myself, Attorney Garrity, and our client, Mr. Terence Crosbie, I want to thank you for your time and attention so far these past several days of trial. I also want to thank you in advance for your consideration as you go back into that jury room and deliberate later today. You were selected as jurors because you told us and this court that you could be fair and impartial, that you wouldn't prejudge this case based on the charge or the fact that the allegations involved claims of sexual assault, that you could set aside any bias or preconceived notions that you might have and decide this case based on solely the evidence put before you, that you would presume our client, Mr. Crosbie, to be an innocent man unless the Commonwealth proved to you all, beyond a reasonable doubt, that he was not. You all swore an oath to do that. As he sits there now, Mr. Crosbie is still presumed to be an innocent man. That is a presumption that you must take back into that jury room with you, a presumption that you must continue to hold unless or until you all unanimously agree that the Commonwealth has proven each and every element of the charge you are considering beyond a reasonable doubt. Now, the judge has begun to instruct you about the law you must apply to your deliberations, and His Honor will have further instructions for you after the Commonwealth gives its closing argument. All of the judge's instructions are important, and I ask you to listen carefully to them all. His Honor has told you that these closing arguments are not evidence, much like he told you that the openings were not evidence. You already have all the evidence. The testimony you heard from the witnesses and their answers. The lawyer's questions are not evidence. It's the witnesses' answers and the observations you made of the witnesses, as well as the exhibits that were entered into evidence. These closing arguments are just that, arguments, from both sides, as to what we suggest the evidence shows and how we suggest you should interpret it within the confines of the rules, the law that the judge will instruct you on. But going back to openings, when Mr. Garrity stood before you, he talked about the Commonwealth's burden of proof beyond a reasonable doubt, and how high of a burden that is. And the judge just instructed you on that. You have a copy of that instruction. I ask that you pay very close attention to that instruction. The Commonwealth has brought this case. This is their case against Mr. Crosbie. It is their burden to prove each and every element of the crime for which they have charged him. And in order to convict him of that alleged crime, they have to convince you all, unanimously, that each and every element has been proven beyond a reasonable doubt. I submit that as a high burden. That is the highest burden we have in our judicial system, and it is the Commonwealth's burden alone. As I said, Mr. Crosbie sits there presumed to be an innocent man. He had no obligation to present any evidence, nor to cross-examine any Commonwealth witness, nor to call his own witnesses, or even to testify himself. I suggest to you that when you consider all the evidence, or lack thereof, that you will find reasonable doubt, that the Commonwealth has not met its highest of burdens, and that in that case, you will come to the conclusion that the only just and proper decision you, as a jury, can make is to return a verdict of not guilty. Now, while any single reasonable doubt is sufficient to find Mr. Crosbie not guilty, I suggest to you there are multiple reasonable doubts in this case. The Commonwealth put on multiple witnesses in support of their case and introduced numerous exhibits. But only 3 people were allegedly present in room 610 of the Omni Parker House on March 14th into March 15th of last year. And that is for what claims happened. And of those 3, 1, Mr. Liam O'Brien, was supposedly asleep. Moreover, he refused to return here and testify in this trial. So really, there are only 2 people who could know what did or did not happen in that room that night. No one else that you heard from saw anything or heard anything at the time says these things happened. This is a case where says she was sexually assaulted by an individual she couldn't identify. Mr. Crosbie says it was not him, that he didn't do what he's being accused of. There's no other evidence of what happened or didn't happen in that room that night, no video or audio recordings, no pictures, no other witnesses to what supposedly occurred. The DNA evidence that the Commonwealth introduced, or lack thereof, cannot tell you what happened. There are only 2 people who could know what happened, and you heard from both of them. Everyone else that was called to testify in this case was not in that room and did not directly see or hear anything about what did or did not happen in that room. whom I suggest is a less than reliable reporter given her intoxication, her memory lapses, and other provably false recollections, gave you her version of events. And Mr. Crosbie got up on that stand, something he was not required to do, and under oath told you he did not do what he's being accused of. I submit to you that, in and of itself, is all the reasonable doubt you need. The Commonwealth put on a bunch of witnesses and introduced a number. I have no doubt that when Ms. Murphy comes up here to speak with you next, she will meticulously review their evidence in her closing and suggest that if you testimony and ignore or choose to disbelieve Mr. Crosbie's testimony, that you can find enough circumstantial evidence to support their argument, to tip the balance in their favor, and to convict. I suggest to you that even if you do credit some of that circumstantial evidence and find that it supports Mr. claims, and to be clear, I submit that same evidence provided by the Commonwealth also supports what Mr. Crosbie has told you, none of it changes the fact that only and Mr. Crosbie can tell you what did or did not happen. I also expect the Commonwealth to suggest that despite any inconsistencies in their evidence, it should be believed that no one deserves to go through what she says happened, that no one would want to put themselves through all this if it didn't happen, that there is no normal or expected reaction to what she says happened, and so her actions leaving the hotel aren't indicative of anything, that she believes her own story, and you should believe her too. But it's not that simple. If it were, you wouldn't be sitting here being asked who and what to believe. Mr. Crosbie can't say why she has said what she has said. But he doesn't need to. It's not his burden. It's the Commonwealth's burden to prove beyond a reasonable doubt that what Mr. says happened did in fact happen. Mr. Crosbie has been unequivocal that it did not. Now, the Commonwealth is asking you to believe her version of events. But when you evaluate her testimony, I ask you to question whether she is a reliable reporter. You heard testimony from Detective McDonough that there were things she couldn't remember throughout the night. You heard testimony that she had been drinking throughout the day and night at multiple establishments. The amount of drinks varied across several interviews and testimony, but despite what she told you about not feeling drunk or about being coherent, her blood draw proved she was intoxicated at 6 a.m. on March 15th.
Listening to the closing arguments there from the defense, in real time, though, we want to point out we have the verdict clock up because the jurors have the case. So just 6 minutes, just getting started there. Why don't we go ahead and bring in our guest for this hour to discuss. Joining us from Martinez, California, criminal defense attorney Ashley Barganquist. Ashley, okay, watching this case in Boston, already the jurors have the case. We're just playing the closing arguments now. Defense up first. What are your takeaways from how defense counsel is doing so far in his close?
Thank you for having me this morning. Now, defense counsel started with a very standard kind of beginning to a closing statement, thanking the jury for their time, and most importantly, reminding them of the presumption of innocence. Now, a lot of jurors think that that presumption of innocence changes throughout the trial, but you really are supposed to take that presumption back until deliberations have continued and begun and completed. So I think that it is important, particularly in a case like this, where it really is a he said, she said, and no physical proof. Because when the people get up, it will absolutely be the Commonwealth saying circumstantial evidence is enough. And they're correct. Circumstantial evidence can support elements. But really, in this case, it is making sure that reasonable doubt is followed. Because what do you have? You simply have he said, she said. So I think that the defense attorney is really emphasizing what he has to.
The defense brought up the state's or the Commonwealth's close. And he said, you're going to hear them say, well, why would she lie? Why would she make up this story? And they're alluding to the fact that she was drunk over the legal limit by a lot at 6 a.m. And getting into that non-report, you can't trust the reporter in this scenario. It is such a detailed, unique story that she told, though, to the jury, that it doesn't have any real upside for her if she's going to go through this process. She is an attorney. To what extent is that going to help the Commonwealth? The fact that she's telling this unique story that doesn't seem to have a motivation behind it other than it happened.
I mean, I think that it is the Commonwealth's primary, evidence and what they're resting their case on, and quite fairly so. Listening to her testimony was hard, right? It was devastating to hear, even, secondhand through a remote show. But I can only imagine that the jury hearing it in person and seeing her was struck by it, because it is very clear that she believes that this happened, right? That this is an experience that she's bringing to the courtroom. So the question then becomes, like the defense attorney brought up, right, that, well, what actually happened? It doesn't mean that she didn't experience it, but what actually happened that night? Because you have a very difficult job as a defense attorney in cases like this, where someone is clearly very affected and is very convincing and clear and emotional on the stand, that you have to acknowledge that they're experiencing something which is bringing them here, because she doesn't have any reason to want to do this other than getting justice, but that just because she experienced something doesn't mean that it was the defendant who is the one that did it to her. And so I think that that is where the defense is really going to have to emphasize their case. It's not necessarily that this didn't happen in any way, but it just didn't happen the way that she said it happened. Because the way that the defendant experienced that night and the way that she experienced that night are vastly different.
Mm-hmm. How about the prosecution handling? How do you expect the prosecution to handle the whole DNA issue?
I imagine that what the prosecution will, bring up and say is that there is definitive evidence that there were two individuals, and that shows that there were two different sexual partners, one consensual and one non-consensual, that night. Just because it doesn't show through DNA that it was the defendant doesn't mean that it doesn't show that this didn't happen. So they'll use essentially that it corroborates that this happened, even if it doesn't definitively narrow down who it happened with. And so then they'll point to the other circumstantial evidence of key cards, timing, etc., to show that it was this defendant. I do think that there is a hole in the prosecution's case because of that lack of evidence, because of the lack of direct evidence, despite this being reported so quickly. However, you also have a lot of circumstantial and a lot of very believable testimony, even with inconsistencies, that the defense is up against. This is a very close case.
Yeah, and we saw that play out the first time around with a hung jury.
Yes.
Will this jury come to a unanimous decision? We'll have to wait and see. Again, we're a little bit behind. We're rolling out the closing arguments. You see the clock ticking. They have begun the deliberation process in Boston. Let's get a break. When we come back, more of the defense closing. Stay with us.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday at 8 Eastern and Pacific, only on Court TV.
Just walking around the room, gathering her clothes and rummaging, looking for her belongings.
Did you look at her?
The room were out, I couldn't, but I didn't try anyway.
Did you touch her?
I didn't.
Did you have any physical contact with her?
I didn't.
Let's go back to Massachusetts now. Closing arguments are underway in the Irish firefighter rape trial.
The defendant is Terence Crosbie. He's accused of raping a woman last year while he was in town visiting for the St. Patty's Day parade.
Let's go back into the courtroom. The defense goes first in the Commonwealth of Massachusetts, and that's what we're listening to, the defense close.
You heard testimony about clinical sobriety and being able to consent to treatment. But those same witnesses also admitted drunk people can answer those questions and follow commands. However she may have presented outwardly, the toxicology report indicated BAC was 0.135 when her blood was drawn. She also testified that she was taking at least one prescription that, when it was prescribed, she had been warned could increase the effects of alcohol if taken together. Detective McDonough told you that the legal limit to drive a car in Massachusetts is 0.08 BAC. There's a reason the limit is 0.08, whether you are driving a car or not. At that point, you are considered impaired. Ms. Griffiths calculated that BAC at 2 a.m. the morning in question would have been between 0.155 and 0.235. The math and the science indicates she was impaired by a factor of perhaps 2 to 3 times the legal limit. I suggest that impairment is reason to question her perceptions and her recollections. Based on all of that, I suggest it's an unreliable reporter, and that unreliability amounts to reasonable doubt in this case. But let's explore some other reasons I suggest testimony should be questioned in terms of its reliability. Whether caused by alcohol consumption or some other reason, the version of events includes missing information, gaps in her memory, and observations that I suggest indicate she is not a reliable reporter. Beginning with her consensual partner. She testified that she spent hours with him, talking, dancing. You saw all that on the various videos. She ultimately had sex with him, but she didn't recall his name, not even a first name. Her explanation wasn't simply that she was too intoxicated to remember, or that she wasn't focused on it, although you heard that a lot in her later testimony. Her explanation was that she was too embarrassed to ask him again. I ask you, does that ring true? She spent hours with him, dancing, kissing, ultimately having an intimate experience. She was clearly comfortable with him. I suggest I want you to believe she was far less intoxicated than she really was, that she's afraid you wouldn't believe her if she just admitted she was drunk and couldn't remember important details. But details matter. And no matter the reason, she couldn't remember a bunch of them. She didn't recall what Mr. O'Brien was wearing, even though she was wearing his sweatshirt at one point in the evening. Again, it's on the videos the Commonwealth put into evidence. She never identified Mr. Crosbie. She didn't recall him being one of the other firefighters she met at the Black Rose. They shook hands at one point. She even hugged him goodbye at another point. The Commonwealth showed you both of those instances on video. She didn't remember that. She says it was because she met a lot of people and wasn't focused on those interactions. But they did happen. You saw it on the videos. Perhaps most tellingly, she denies that Mr. Crosbie was in room 610 when she and Mr. O'Brien first got there after the Black Rose. Her testimony was not that she didn't remember him being there or even that she wasn't focused on it. No, she was sure that he was not in the room. Adamant he wasn't there. She denied it perhaps as many as 5 or more times during her testimony. She told the police repeatedly no one else was there in that room when she and Mr. O'Brien arrived. She told you, the jury, the same thing. But we know that's not accurate given the records and videos the Commonwealth introduced. The lock interrogation records and videos from the Omni Parker house confirm he was there. Mr. Crosbie testified he was there. I suggest to you these are all reasons to question her story and her reliability as a witness. That these amount to reasonable doubts. But there's more. Indicated the bathroom light was on by the time Mr. Crosbie re-entered the room at 1:55. That there was enough light to see throughout the room. That's something Mr. Crosbie got up on the stand and told you wasn't accurate. It was dark and there were no lights on. She also indicated she didn't know Mr. O'Brien had a roommate. Again, despite having have seen Mr. Crosbie in the room when she arrived. I suggest to you that room 610 is not a very big room. You have pictures of it in evidence. I suggest it would have been hard to miss the 2 suitcases, one by each bed. You have photos of the tattoos Mr. Crosbie has. They are not small. They cover the insides and outsides of his upper arms. There are big ones on his legs, too. She testified that the bathroom light was on, that she could see her alleged assailant, that her alleged assailant held her with his hands on her shoulders and her chest area. I suggest it would be very difficult not to see any of the tattoos on Mr. Crosbie's arms if he had held. Similarly, if he had chased her around the room fully nude and held her against the wall in a similar fashion, it would be almost impossible not to see some or all of those tattoos. Never indicated that she saw tattoos on her alleged assailant. She testified that she didn't notice any scars, birthmarks, or tattoos. Again, the explanation being that she wasn't focused on that. But details matter. She remembers other details, but not the ones that don't support her narrative. I suggest this, too, amounts to reasonable doubt. What else about her story doesn't quite make sense? Initially told police that her alleged assailant was about the same height as her. She testified to being between 5'8" and 5'9". Mr. Crosbie is 6'1". He's 4 to 5 inches taller than her. If he was holding her up against a wall, says her alleged assailant did, I suggest that is a very noticeable height difference. And again, if he's chasing her around this small room, bumping into walls and furniture, trying to get into the bathroom after she locks it, does it make sense that Mr. O'Brien isn't awakened? Does it make sense that the alleged assailant wouldn't be afraid of awakening him? Does it make sense that she didn't call out to Mr. O'Brien for help? Does it make sense that she didn't call for the police or from the bathroom? She told you it was locked. She told you she wanted to get to safety, that she got her belongings, locked herself in the bathroom, got dressed from there and left, that she didn't go back into the room. So she had her phone with her. I submit all these questions also amount to reasonable doubt. Testified that her alleged assailant entered the room without her noticing, that he discovered her in the other bed apart from where Mr. O'Brien was sleeping, that her alleged assailant stripped down completely naked without her noticing, that he pulled the covers back and off without her noticing, found her to be completely naked, and got on the bed and positioned her in a manner where he could insert himself into her, again, without her noticing, and that he did so. He supposedly started having sex with her without her noticing for some unknown amount of time.
Interesting close. We're going to have to continue to see what he has to say there. Closing arguments there in Boston. We still have the verdict clock up because they are just deliberating. Only 25 minutes in so far in this case against Terence Crosbie. We'll be right back.
I woke up to somebody on top of me, inside of me, in his penis in my vagina, on top of me, telling me, you like this, he couldn't give this to you, I'll give it to you, he's a loser. I was focusing on getting out. I was focusing on getting to safety.
That was the alleged victim on the stand. During this case, both the defendant and the alleged victim took the stand. It's going to be up to this jury to decide who was telling the truth because one of them is lying.
Yeah, it's a tough one. I mean, I don't know which way this case is going to go, but I have really enjoyed watching this one.
Yeah, first time around, it was a hung jury. We'll see if that's the same this time around. 31 minutes-ish and counting. The jury in real time has been at it. Let's go back into the courtroom, pick up more of the defense close.
When she does awaken, she claims he says things about his friend not being able to do it, that he's a loser. Mr. Crosbie told you. Those are not words he uses. Does it make sense he would suddenly start to talk differently? She doesn't notice his tattoos. She doesn't try to awaken Mr. O'Brien. She gets away. She gets dressed in the bathroom, leaves. She doesn't run away. She walks. She doesn't ask the hotel staff for help. She doesn't call the police. She texts Daniel Jacobson. But again, she doesn't ID Mr. Crosbie. Doesn't say one of the guys from the Black Rose assaulted me. Doesn't say some Irish guy with tattoos assaulted me. Just some guy who was saying things. Does that recounting make sense? Maybe. I'm sure the Commonwealth will tell you it does. But I suggest it raises a lot of questions, and those questions amount to more reasonable doubt. I expect the Commonwealth will suggest to you in its closing that despite intoxication, inattention, confusion, or lapses in her memory, and all the important details she missed or forgot, that she should be believed. But the Commonwealth's theory of the case is that Mr. Crosbie was on the prowl to have some sort of sexual encounter during his trip to Boston, a trip that had been planned since May of 2023. That's when his ticket was purchased. That he kissed another woman in the Black Rose, but she left and he didn't get what he wanted. That he went back to the bar and sat alone at his table, watching Mr. O'Brien, feeling depressed and jealous. So he went back to the hotel alone and then took advantage of when he found her asleep in his bed. Mr. Crosbie told you that's not what happened. That he could have gone home with the woman he met at the Black Rose. He admitted to you that the thought crossed his mind, but that he declined to go with her. He told you the bars were still open, that there were plenty of people still out and about. He told you he'd been to several other establishments earlier in the day. He knew where they were and that they had people in them, including other members of his brigade and other women. Does the Commonwealth's narrative make sense? Does it make sense that if he truly was on the prowl for sex, he would decline the opportunity with the first woman he had spent all that time in the Black Rose with? That he would leave a bar with plenty of other women drinking and dancing? Does it make sense that he wouldn't go to any of the other bars within walking distance that he testified to going to earlier, looking to meet other women? If that's the Commonwealth's theory, did it make sense that he went home alone early before and Mr. O'Brien even left the bar to go to bed, only to then leave the room and wait for 2 hours in the hallway? He could have gone out back to the bars. He could have done that instead of sitting in a chair in the hallway waiting to go to bed. I suggest that that's the Commonwealth's theory of the case. It doesn't make sense, and that too is reasonable doubt. Now, I also expect the Commonwealth will ask you to consider the DNA evidence that they presented. Even though Mr. Crosbie was excluded as a source of the DNA from the genital swab and the breast swab taken from during the first round of testing, I suggest that is reasonable doubt. I expect the Commonwealth will ask you to consider the YSTR testing, that 2 distinct male profiles were detected, and so one must be Terence Crosbie. But to come to that conclusion, you would have to ignore that you heard testimony that the sample that was tested was not suitable for comparison, that it had inconclusive results, that the results do not support any conclusions. You'd have to ignore that the Commonwealth's own witness told you there is the possibility that transfer DNA or contamination could explain the presence of male DNA in a sample. Their expert told you that in cases where the level of DNA being tested is low, those instances are more susceptible to detecting transfer DNA. This is a case where the BPD crime labs sent out their sample to Bodie labs specifically because the male DNA detected was so low and they couldn't identify it. And speaking of transfer DNA, the Commonwealth's witness testified that it can come from any number of sources, known or unknown, that it's possible that it could have come from someone interacted with or from outside sources if there was contamination. By their witness's own admission, it's entirely possible that the male DNA detected is not Mr. Crosbie's. But even if it were, and again, I'm not suggesting that it is, Terence Crosbie was not included as a source for any DNA tested other than in his own underwear. But even if it were his DNA, there were multiple opportunities for transfer DNA to be found. Mr. Crosbie shook hands. They hugged. His towel and dirty clothing were on the bed in room 610. It's even possible it could have passed from Mr. Crosbie to Mr. O'Brien and on to me. The Bodie scientist told you her testing cannot tell you how or where the inconclusive male DNA they detected came from. The Commonwealth put into evidence that Mr. Crosbie supposedly placed his penis inside, that he put his full naked body against hers, and he put his hands forcefully on her breasts, that he pushed her up against walls while nude. And yet none of that resulted in the detection of a profile matching Mr. Crosbie. It did detect a profile matching Mr. O'Brien with regard to breasts, the same location the Commonwealth says Mr. Crosbie had his hands. But still, nothing that includes or matches Mr. Crosbie. Despite this, they want you to believe that it must be him, because who else could it be? But as we just discussed, their own expert says it's absolutely possible that male DNA that was detected could have come from other sources, and they cannot say that it came from Mr. Crosbie. I suggest to you that the DNA evidence that the Commonwealth is relying upon actually interjects more reasonable doubt to this case. I also expect the Commonwealth to ask you to consider Mr. Crosbie getting on a flight as consciousness of guilt, that he fled because he knew he was guilty and didn't want to get caught. But I ask you to consider that he didn't try to leave on the 15th, and then on the 16th he sat with police and answered all their questions. He gave a recorded interview, he gave all his contact information, he questioned what they were investigating. He was told he was free to go about his business. Despite that, he told them he wasn't going anywhere and would speak with them again. He didn't walk out of there and immediately book a flight. He didn't hop in an Uber and get out of there. And after being accused of a serious crime, he took a walk to collect himself and went to seek advice from his superiors.
Still with us, criminal defense attorney Ashley Bargainfest. Ashley, all right, more into the defense closing here. He's addressing the fleeing, talking about what the prosecutor is going to say. Consciousness of guilt. He booked that flight. He wasn't supposed to leave for several days later. Defense counsel's addressing it there. Do you believe his strategy with the way he's addressing it is a good one?
Absolutely, because the defense will not get another chance to talk, right? The point is that he has one go. He has to give this closing and make sure that it covers everything. Because the burden rests with the prosecutor, they get the last word. And this can be incredibly difficult for the defense because then the prosecutor can bring something up, connect some dots, make an argument that just cannot be addressed. And so it's the last thing left with the jurors. So the defense attorney has to address these things. He can't just leave them out there. There has to be this argument in the jurors' minds when they hear the prosecutor's final statement, that closing statement, so that they have it addressed when they go back into deliberations. Because the truth of the matter is, regardless of where the presumption of innocence lies or where the burden of proof lies, if there is a question in a case like this where there are emotions, a jury often defaults to doing what they emotionally want to do. And because of the emotionality of the alleged victim's testimony here, they might want to give her justice. And while that is not proven beyond a reasonable doubt, they want to. And so they're looking for an excuse. That's not how the presumption of innocence works. That's not how the burden of proof works, but it is all too often what happens. So the defense attorney is doing a great job addressing what will be brought up so that it is addressed by the time the jury hears it.
During his testimony on yesterday, the defendant I'm talking about, he says that he walks into the room, sees those two, and leaves 2 hours, gives them their privacy, then eventually goes back in. He hears Liam snoring like a freight train, doesn't really notice the girl at all. No one's in his bed. The bed has not been unmade. Opens the bed up and goes to, sits in bed, and then he notices the girl gathering her stuff and leaving. His version of events is so different than hers in that the bed is made and there's no woman in the bed. She then, it would have to, if he's telling the truth, have to have made the whole thing up, not a mistaken identity. The whole, I left Liam's bed because he was snoring and he was spread out like a starfish, is what she said. So I went to this other bed and slept. His version says that's not true. To make such a distinction, it really puts the jury in a position of one of you is lying and the other one is not. Other than, like nuance, well, I got there and she was in the bed, but I didn't touch her. No, he's saying she wasn't even in the bed. Who does that help, if anybody, and to what extent does it really come down to who they believe?
I mean, this is a case of he said, she said, right? But in my mind, I believe the fact that it is such a departure helps the defense, because it just makes more sense if someone is lying, right? If he didn't know, right, whether or not there would be DNA evidence on her or marks on her or anything like that, would be that he came back afterwards, found her in his bed, and, laid in bed anyway. Or maybe even crawled in bed before realizing that there was someone else in bed because it was dark, right? There are so many, I guess if you would want to say, better lies that he could have said if this was a lie. But then again, you have the prosecution who might argue that, how would that be true? Even if she's intoxicated, how is everything that she recalls after her intimate encounter with the other individual, Liam, so wrong, right? How is that explained? But I would argue that it doesn't make sense for either of these lies to be so separate from one another. And so if it doesn't make sense for either of them to be so separate, there is still a presumption of innocence and there is still a burden of proof.
Yeah, and Ashley, the burden of proof is so high. They're supposed to be convinced, firmly convinced that he did it. And I just, I don't know how they're going to fall here, but that's why the prosecution has such a high burden. I don't know. We'll see what happens. Ashley, thanks. We're going to squeeze in a break. We're going to have the remainder of the closing argument from defense counsel coming up right after this quick break.
I've committed so many horrific acts over and over and over.
Do you think you deserve to die for murdering those innocent people?
You tell me. I wish more than anything, David, that I would have done something other than the things I've done in my life.
Are you really a changed man, or is this some kind of stunt?
Interview with a Killer. 2-hour season premiere. Saturday night at 8 Eastern and Pacific. Only on Court TV.
Back now to Boston, Massachusetts, where jury deliberations are underway in the retrial for a man charged with raping a woman. This was last year.
Terence Crosbie, he's an Irish firefighter. He's visiting Boston to march in the St. Patrick's Day Parade. Prosecutors say that after a night of drinking at several places, including the Black Rose, Crosbie ends up back in his room with his buddy, and there was a woman in his bed who had just had sex with his buddy consensually, and the prosecution says that he then had sex with her, and it was absolutely rape.
Crosby's defense team refutes those claims, saying that their client denies those allegations. He maintains his innocence. Why don't we go back inside, listen to the remainder of the defense's closing.
Then circumstances changed. He came back to his hotel room to find it unlocked and the door ajar. And you can check the lock interrogation records the Commonwealth put into evidence. They support Mr. Crosbie's story. He knew it was not Liam O'Brien that had opened the door. He'd just been around the corner with him. He wasn't there. He didn't know by whom or why his door had been opened. He panicked. He was in a foreign country, accused of a crime he has told you he did not commit, with his room left open, not knowing if someone was looking to retaliate for what had claimed was done to her. And he panicked. He got on a flight and tried to go home where he felt safe, where he could get help. I suggest to you that's not consciousness of guilt. That's a reasonable reaction. That makes sense. Getting on an earlier flight if available, that makes sense. He told you why he did it. He told you it wasn't to evade police. He was scared. Not because he'd done something wrong, but because someone was making a false claim against him and he didn't know what to do or what was going to happen. Now, Mr. Crosbie took the stand. He didn't have to. It's the Commonwealth's burden to prove their case against him. Mr. Crosbie has no burden He doesn't have to prove his innocence, but he took the stand and subjected himself to cross-examination. I suggest his account was consistent with much of what the Commonwealth itself put into evidence. He told you about being in the room when Mr. O'Brien and Ms. Creamer arrived. Something supported by video and lock interrogation records. He told you about waiting for 2 hours to give them privacy. Again, supported by the video and lock records. He told you about finally going back to the room and knocking, opening the door and calling into the room multiple times before entering. Again, supported by the lock interrogation records. He told you it was dark and he used his torch to find his way to his empty bed. He told you he heard rummaging around and that she eventually left without any interaction with him. He told you about his tattoos that Mr. never mentioned. He told you about his suitcase that Mr. never noticed. He told you about his police interview, how he answered their questions and cooperated with them, how he denied any wrongdoing then and again to you, the jury. He told you about his decision to get on a plane and leave, again, after panicking when he found his room left open and after being accused of sexually assaulting. And again, the records back up his story. But most importantly, he took the stand and told you, in no uncertain terms, he did not do it. All of this, I submit, is reasonable doubt. I suggest there is absolutely reasonable doubt in this case. And because of any one, or some, or all of these reasonable doubts I've suggested to you, I submit that you must find that the Commonwealth has not met its high burden, that they have not proven beyond a reasonable doubt that Mr. Crosbie did any of the things he has been accused of, which he has taken the witness stand and denied under oath, and that they have not proven each and every element of the crime charged beyond a reasonable doubt. And for those reasons, I ask you to return the only just, appropriate verdict, not guilty.